The United Kingdom continues to be a highly attractive destination for global talent. However, individuals residing and working in the country on long-term visas are facing growing uncertainty about their future status. The government's white paper, published in May 2025, raised significant questions regarding the criteria and timing for acquiring permanent residency and citizenship. The Reform Party's proposals, announced in a speech by Nigel Farage on the 22nd of September 2025, have added further unpredictability to this evolving debate. Before we continue, if you've not already, subscribe to our channel and ring the notification bell for upcoming updates. For those already on the path towards settlement, the shifting landscape can be particularly concerning. Timelines that once appeared well-defined may now be subject to extension, and there is ongoing discussion about the potential removal of existing rights. In this context, it is more important than ever to remain informed about the current framework, monitor possible developments, and take proactive steps to safeguard long-term immigration objectives. The current pathway to permanent residence and British citizenship at a high level. The current rules are as follows. Most individuals can apply for permanent residence, known as indefinite leave to remain done. After 5 years of continuous lawful residence in the UK. Once you have ILR, there is generally a further 12-month wait before applying for citizenship, unless you are the spouse or civil partner of a British citizen, in which case that 12-month wait does not apply. Routes like Global Talent or Innovator Founder may permit ILR after just 3 years, though the 5-year total residence requirement for naturalization remains. Applicants must satisfy requirements including passing the Life in the UK test, meeting English language requirements, showing good character, having appropriate residency, and limits on absences. What is proposed? Government White Paper, May 2025. The government's white paper proposes extending the ILR qualifying period from 5 to 10 years for most routes, excluding partners of British Chambry citizens. It is unclear at present whether this will apply to existing migrants on a pathway to ILR, and this is the subject of further consultation. More stringent English language requirements. Moving towards an earned contribution model where settlement and citizenship may be available sooner for people who can demonstrate strong integration, economic contribution, or working key growth sectors. 2. Reform Party proposals, September 2025. The Reform Party has announced its own set of suggestions, including abolishing the rights of migrants to qualify for ILR after 5 years. Migrants would instead have to reapply for their visas every 5 years. The indication is that this would be applied retrospectively to migrants who already hold ILR. Higher salary thresholds. More stringent residency requirements and increased English language requirements, raising the average wait for UK citizenship from 6 years to 7 years, preventing anyone other than British citizens from accessing public benefits. These proposals, whilst not part of the current law, contribute to the political debate and may influence future legislation or policy adjustments. Is this a cause for concern? Although these proposals are not yet law, and the Reform Party is not currently in government, there is growing political momentum around certain themes. Across much of the political spectrum, our professionals are seeing support for longer and more demanding pathways to residency and citizenship, greater emphasis on measurable contribution and integration, stricter adherence to requirements such as absence limits and language standards. This means that, even if the details differ between parties, the overall direction of policy may be towards tougher rules in the years ahead. In respect of retrospective application of any new rules, this cannot be completely ruled out, however. It is worth remembering that previous attempts to apply immigration reforms to people partway through their journey have been successfully challenged in the courts. Judges have upheld the principle of legitimate expectation and fairness, recognizing that individuals make life-changing decisions moving their families, investing in the UK, and building careers based on the rules in place at the time. While no guarantees can be given, past precedent suggests that sweeping retrospective changes would be open to challenge and potentially difficult for any government to enforce. Looking ahead, individuals currently in the UK on a visa who meet the requirements for ILR or British citizenship may wish to consider applying under the current rules in order to secure their status on, quote, more favourable terms. Obtaining tailored legal advice is strongly recommended to determine the most appropriate approach in light of individual circumstances. Make sure you subscribe to our channel and ring the notification bell for upcoming updates. Have a great day!